Hello, this is Matt on the Moon Lambeau channel. Ripple says let John Deaton and the 16,000 XRP holders that he represents, let them intervene in the court case that the SEC has filed against Ripple. Ripple's all on board here. They have a couple ways in which they clarified specifically what they want, but they're on board. Not surprisingly, the SEC not on board. You know, it's just so fascinating, and it does feel like a slap in the face, but the SEC, while their mission is supposed to be to protect investors, does anybody listening to this feel like they're being protected by what the SEC is doing? I sure as hell don't. I think most people that hold XRP feel like they're being attacked by the SEC. And so, not surprisingly, given that this is the case, the SEC does not want XRP holders' voices to be heard. Because they want to paint a narrative which is not in line with reality, which is in part that this idea that XRP itself, XRP to its core by its very nature, is a security. And I'm going to highlight, even just speaking verbal policy stuff from higher ups at the SEC, I'm going to paint a picture in this video of why they're not just hypocritical. Like, the left hand of the SEC doesn't know what the right hand of the SEC is doing. It's complete absurdity. But it was refreshing to see what we got from Ripple here. And a lot of this is just recently unfolding over the last few hours. So lots to talk about. But I do want to be clear at the outset, I don't have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything that I say or write. I'm just an enthusiast who enjoys making YouTube videos as a very fun hobby about Ripple and XRP and cryptocurrencies, and that is indeed all that's going on here. Now, some of you on social media may have seen a tweet by attorney John Deaton from a little bit earlier in the day, which read as follows: time-stamped prediction. When you can't attack the message, attack the messenger. Now, I was messaging back and forth with John Deaton a little bit earlier today, and he sent me an email with some specifics, which I want to cover, but I'm going to almost 100% hold back in this video. So fear not, John, if you're listening, don't worry. I sought additional clarification from John on what it may be okay to or not cover, just to be super duper sure. But he did already say, once the SEC files what they file, it'd be okay to talk about it. But what I can say is in line with what he already put out here, because it was partly on this topic. John did think indeed, and there's a reason he put this tweet out as a time-stamped prediction, and it was before this was all filed. He said, when you can't attack the message, attack the messenger. And so it's true. In this document, and I'm probably not going to focus on it so much in this particular video, plenty more to talk about in future videos, but yes, they did attack him rather than solely focusing on the message. So good prediction, John. You were absolutely correct. And so then he retweeted his own tweet and wrote, "Thank you for being so predictable," and he tagged me along with a few others. And so I'll tell you what, I can say this because it's nothing specific, but the SEC fell for a trap effectively. They don't know they did it. John told me what the plan was. And as soon as he says it's okay to talk about it, and I think it's already okay, but I just wanted to be super duper clear, so I'm not going to say it in this video, but he set a trap and the SEC fell for it. And he just said, Matt, just wait until the SEC files what they want to file, today, when it comes out today before talking about it. But I feel better just waiting a little bit. But I'll cover it in a future video. But suffice it to say, we still got some really interesting things out of these documents here. So take a look at this. Let's start with this, because again, there are two things that were filed, one from the SEC and one from Ripple. And look, I'm not going to go extremely into the background. I'm going to assume to this point that we're all pretty well caught up to speed. But if you're not sure what we're talking about here, given that the SEC has filed against Ripple, that dates back, of course, to December, claiming that they sold XRP as an unregistered security. Well, it's complete nonsense, and the interests of XRP holders are not being sufficiently represented in this case, but this case could have extreme impact on said holders. And so as a result of this, attorney John Deaton is seeking to intervene in the case. And so he filed an actual motion. He had to like file the file effectively. Like, you have to send in a document to get approval from the judge to then file the motion and then hopefully get approved. So we'll see if ultimately in any capacity there is some sort of approval here. But it certainly is the case that the SEC, as I stated at the outset of this video, not looking out for us. And Ripple, nothing against them, but my gosh, like, is it supposed to be their job to like defend every single developer building on top of the XRP ledger and every single individual holder that is using XRP for any number of use cases that has nothing to do with Ripple, for which Ripple has no say whether or not they can do such things? Well, of course not. You know, look, I've joked in the past that Ripple has more money than God, but come on, man. What are they going to do? Like, look into the specifics of what every human individual's, or just take on additional expenses? It's just completely unrealistic here. And so anyway, John Deaton started a new organization called Crypto Law. On Twitter, they're at Crypto Law US. Their website is crypto-law.us. You should check them out if you've not yet done so. And they shared the following regarding the filing of the SEC in this. And it wrote simply here, Crypto Law wrote this and said, analysis from John Deaton will follow, but this glance at the SEC's table of contents says a lot. And so this is a screen grab shared from Crypto Law. I'm not going to read all of this, but I think it speaks volumes. It does. Maybe a couple highlights here I'll cover. Movements, so that'd be John Deaton along with the 16,000 plus XRP holders that he's representing. All right, movements lack a cognizable interest in this action. Yeah, what John Deaton has stated very clearly. Apparently, it's not even interpretable. It's just not even possible. And then they wrote this up here that John Deaton and the 16,000 plus XRP holders constitutionally and statutorily, I think I said that right, barred from intervening. Oh, that's going to be fun. Gosh. All right, there's going to be way more videos on this stuff in the future. I just need to move on. But take a look at this. So the Crypto Law Twitter account did a great job of highlighting some of the most important stuff from Ripple's filings, making their case as to why John Deaton deserves to intervene in this case, should be allowed to intervene in this case while representing the 16,000 holders of XRP. So check this out. Here are the key points. XRP holders, and this comes from Ripple now, should be allowed to participate in this case as independent holders, developers, and users of XRP with no relationship to defendants. They have strong and distinct interests in the regulatory status of XRP. Yeah, truer words have never been spoken. And and I think back to something from months ago when John Deaton, he may have been with the On the Chain Live guys. I think that's where I saw this. I could be mistaken, but he brought up, he's like, look, I'm just doing this because as far as XRP holders are concerned, we're basically our own unit. We're within this math equation, right? And effectively stating, he did state, he's like, I don't know if Ripple knows what I'm doing, and if they do, I don't know if Ripple would be happy with what I'm doing, or maybe they'd feel like it's unnecessary interference, but this is the right thing to do. And so that goes back to when he first filed anything, which was on January 1st of this year. And so it is cool to see, because that's reasonable uncertainty, not knowing for sure what Ripple wanted, but it frankly didn't matter. In the end, like, it was the right thing to do, is move forward regardless. It is still cool to see that Ripple ultimately, seen and very, very, very well aware of what John Deaton is doing here, they approve of it. That's awesome. I like that. So anyway, moving forward now. The SEC cannot, and again, this is a quote now from Ripple's lawyers, which is just quoted here by Crypto Law. SEC cannot represent the movements or other participants in the existing functioning XRP market while seeking to destroy that market and frustrate the real purposes for which movements hold XRP. There you go. It sounds bold, and I like that. It's accurate. SEC is seeking to destroy the market of XRP. And how is that in line, of course, with the interests of XRP? Of course it's not. And within the interests of XRP holders for the SEC to have their way. No, not at all. And then continuing, merely by alleging its novel theory, the SEC imposed billions of dollars in immediate losses on third-party XRP holders, dried up XRP liquidity in the United States, and chilled third parties from continuing to develop applications for XRP. And just think about it, it's provably true that third parties, it's absolutely impacted them. And so if XRP, by the nature of existing, indeed is a security, how the hell would that impact third parties? Third parties that build code on top of the XRP ledger. That's why it's so offensive what the SEC has been stating here. It's not logical, it's unethical what they're doing, and it's hypocritical. Continuing. And this is again from Ripple, as cited by Crypto Law. Movements are innocent retail holders with no connection to Ripple who have already felt consequences from the SEC's ill-advised jurisdictional overreach. Their desire to be heard is understandable and legitimate. Thank you, Ripple. Indeed, I'm glad that you see that and appreciate that. But in hindsight, it's one of those things where it feels like obvious that, of course, Ripple feels that way about XRP holders, but you still never know for sure, right? Like John's concern earlier before Ripple spoke out on anything having to do with this. They could have easily just not have liked the interference for X number of reasons, but John, you know what? If anything, I already thought you were doing a bang-up job, but Ripple agrees with you. I hope you're listening, John. You are doing a bang-up job. You got Ripple here agreeing as much. Anyway, the SEC, despite its claims to protect them, is acting against their interests, that's XRP holders' interest, acting against their interests and grossly misrepresenting the circumstances of their purchase and use of XRP. Ding, ding, ding. Absolutely. The SEC, these people are liars. I'm not making a blanket statement about all of them, but the ones that are that have been writing up all these court filings in the initial case, like blatant lies and misrepresentations. It's disgusting and repulsive, and they caused multi-billion-dollar losses of holders across the planet, and they don't give a damn. They don't care about you. That much has been made clear. Continuing now. The SEC says that XRP is a security and always has been. Defendants say that XRP is not a security and never has been. Movements have a special reason to argue that whatever XRP may have been in the past, it was not a security when the SEC filed this suit late last year. Ripple notes that the concept that the regulatory status of a virtual currency may change is not original to them or to John Deaton, but the SEC's own William Hinman said it in his infamous 2018 speech where he said Ethereum was not a security. Exactly. So this is I've been talking about this concept on my channel for about 2.5 years now, just as long as I've been running the damn thing. It's this idea that a cryptocurrency can go from being centralized to decentralized. And so we've always had there's always been this idea, and Brad Garlinghouse has cited as much. Brad Garlinghouse, the Ripple CEO, has said, look, in terms of whether or not something is security, it's kind of like a hard break, whereas if Ripple goes away, this XRP thing, it continues to exist out in the wild, right? That's something that does matter. That is a pretty damn hard break there. And there are other things to consider fine, but it's still a pretty damn hard break, I'd say. And so it's interesting to see that Ripple's stating, even if, the lawyers making this case, even if you want to argue that XRP was sold as a security in the past by Ripple, the idea that it still is a security today does not make sense, and that's effectively what they were communicating right there. And so I pulled, and so then Crypto Law linked to this, and here we go. I'm going to pull this up here. So this is a piece from Yahoo Finance, and this was from, what's the date? June 14th, 2018, so almost 3 years now. And it's titled, SEC announces cryptocurrency Ether is not a security. So here's the relevant portion of this. And so William Hinman, he was at the time some sort of director at the SEC. I can't remember his exact title. Doesn't matter. But here's what the article says. Hinman said that the SEC will not be changing cryptocurrency and digital asset rules, but rather would be applying them. Previously, Bitcoin and Ether may have been offered as securities, like shares of a company, which would have required registration with the SEC. But a consensus has emerged that they behave and are treated like commodities, similar to gold and oil. And here's a quote from Hinman. Can a digital asset originally sold in a securities offering eventually be sold in something other than a security? How about cases when there's no longer a company involved? I believe in those cases, the answer is a qualified yes. Well, there you go. Look, I've been saying this freaking forever. And it's not just me that's been saying it, of course, but it's just to know that this is the case, to know that the SEC agrees with this, but then to have their legal team go after Ripple pretending like William Hinman didn't say this, which was setting verbal policy for the damn SEC, that is disingenuous and disgusting. They're pretending like this didn't even exist. XRP today is a security? I'm sorry, excuse me? No, I don't think so, good sir. Moving on from crypto law, citing what Ripple wrote. A ruling that XRP is an investment contract threatens to go beyond the multi-billion-dollar immediate losses inflicted on XRP holders at the start of this action, and the ongoing throttling of U.S. liquidity to destroy an innovative and promising technology that exists independently of Ripple. Defendants must speak for their own interests. The XRP holders can and should be permitted to speak for themselves. I gotta love that. And in doing so, will shed light on the interests of many other people and businesses that stand to lose existing resources and future opportunities if the SEC's overreach succeeds. Exactly. That's a perfect, fantastic highlight of this whole thing. And if you go down to the bottom of the Ripple official document right here, which is many, many dozens of pages, if you go to the conclusion, I did want to highlight this. Okay, so here, this is just like a sentence, or 2 sentences. So I wanted to read this. So this is Ripple's conclusion at the very tail end of this document. They wrote, defendants support the named movement's participation in the case. Although defendants oppose movement's motion to intervene to represent a putative class, the court should permit them to participate as amici with elevated rights or as interveners with limited rights. And so I'm assuming I said that right, amici, A-M-I-C-I. Okay. Now, with me not having a legal background, I'm not going to pretend to know exactly what that means and what the implications are, but I still wanted to highlight it just to make a simple point, just as a simple observer here, that Ripple, they agree clearly with the most important points put forward by John Deaton on behalf of the 16,000 plus XRP holders, and they want to make sure that the movements, as they're called here, the 16,000 plus XRP holders and John Deaton, have an opportunity to speak here. Now, as far as the implications of what it would mean, and Ripple's opinion of just having some sort of limited ability to intervene. That idea was actually talked about by other attorneys, including, for instance, Jeremy Hogan, many of you may be familiar with. He's become also, in addition to John Deaton, they've really both actually become very famous, I'd say, in the XRP community. And so Jeremy Hogan, I remember him talking about this idea, and I don't remember all the specifics. I take in a lot of crypto information on a daily basis, though. So, but he was just talking about this idea that, if you just give a effectively full ring, I don't know what the legal term might be for this, but, it would be set up in such a way that there would be 3 different parties within the judicial proceedings that have like an equal standing. This is the way that I took it when he was describing it anyway. So hopefully I'm doing this justice, but he thinks more likely if there's going to be any, this is what Jeremy Hogan said, if there's going to be any sort of opportunity for intervention here, that it may come with limited rights. And you can see here what Ripple stated is that it looks like it makes more sense for them to be able to intervene with perhaps with limited rights. And so that's in line with what actually Jeremy Hogan, another attorney, thought would be more likely if there's any sort of intervention allowed at all. So hopefully there is, and we'll see what comes to pass here. So again, that's the best that I can describe it, not having a legal background, so I apologize if that was sloppy, but I gave it the old college try, right, guys? So how about that? I'd say good news on the whole. I'm really looking forward to seeing what other attorneys have to say about this, including John Deaton, because he's definitely gonna come at this, and then have a response in terms of what the SEC had to say. Because I didn't focus so much in this video as far as what the SEC had to say, because it's just too much content otherwise. But also looking forward to see what other attorneys have to say on this. And ultimately, the most interesting thing will be on this topic of this case anyway, and the subject of the case, would be whether or not intervention of any kind is ultimately allowed. So cross your fingers, let's hope so. because I think that's what sounds right. But I'll go ahead and wrap up there. I am not a financial advisor. Do not buy or sell anything because if anything I say are right, that would be a very, very, very bad idea. Until next time, to the moon, Lambo.